Hello. I'm going to ask if you guys can hear me, so a quick response would be awesome. Okay, so I'm going to just give it a moment for other individuals to come in. Buffering image, we hear an echo. It could be the computer I'm on, or let's see if the microphone settings, if I can play with it. On my end, I really cannot tell much of a difference other than the echo. Can you hear all right? Can you understand me? I'm going to hope the answer is yes. And while you're doing that, I'm going to attempt to pull up a chair and have a seat. Buffering image. Okay, so maybe it's internet as well. Has the buffering image improved any? I'm going to wait for a response on that. And if it looks like we have improved on the buffering and all of that, then I am going to go ahead and attempt to get started on this topic for today. So as I wait just a couple of minutes to get started, one of the things I do want to bring up is we're getting close to the end of the semester. So my students actually will have one more SABA legal supplemental session. The SABA legal sessions always take place on my personal Instagram account, so my students can find them and find the information that they can use for their class material. So as far as strictly legal information, I have one more live planned on SABA Legal Live, and that's going to be hosted on my personal Instagram channel. It is supplemental material for my students. It will be extremely law-based. For those interested in what that would be, we are actually dissecting the grounds for appeal and deciding ourselves what would be the strategies we might use as we go forward in the appeals process ourselves. So if my classroom were taking his case, which grounds of appeals would they attempt to use and why? What would their strongest reasons and grounds be? Because not all grounds are equal. So if anyone is interested in that particular topic, as I said, it's going to be very legal focused, and it's going to definitely be something that is interesting for my students. It's going to be very helpful supplemental material for the community as well. Hopefully, this might be something of interest to you to see what we have considered to be the stronger arguments for the grounds versus what we think would be weaker arguments, what we might decide to discuss and what we might put on the back burner. So that's something that will be coming up before the end of the semester. So hopefully that would gain some interest within the community as well. All right, so that's basically what is upcoming on the Saba Legal Live, the ones that are very dedicated to my students and obviously open to the community always. As for what is coming up with VLM, we're doing a Q&A session. I already have several questions in hand, so I will begin with those. Any questions that I don't cover have either previously been covered or will be covered in my legal lives for my students. So anything that I don't cover there would be those. So let's get started. So I've got several devices open with me today. Give me a moment while I get myself situated and open up my questions. Interestingly enough, okay. So the first question that I have is really appeal related. It says, and I'm not going to read it all in the full entirety because there's a lot of information on top that's not relevant, a lot of information at the bottom that's not relevant. So I'm just picking out the actual question from this. So the appeal is a very long process. You mentioned several times that this is completely different from a trial. If this is so different from a trial, what is the court hearing that we are hoping to receive from this? Basically, they're saying is, what's the court hearing going to look like if we get one? So appeals, as we've discussed previously, are a completely different animal than a trial. A trial is when a suspect is presumed innocent, and the trial is there to decide if that person should be found guilty on the indictments with which they have been charged. At the end of a trial, a person is either found guilty or they are vindicated and they're let go because they're found innocent, they're found not guilty. So as a person goes through the trial system, if they've been found not guilty, then they're obviously innocent, they've been vindicated, they're free to go. However, if the person has been found guilty, then that person is no longer free to go. A guilty person, particularly a person who's been found guilty of criminal charges that have sentencing attached to it, then loses their freedom because, again, now they are guilty as charged and they then serve their sentence. An appeal is not a trial. An appeal is the next stage of legal process that exists for one very important reason. It exists for people to petition a higher court to examine the trial. This higher court has the legal authority to examine the trial and the investigations that took place, both preceding the trial and during the trial and anything else attached to it, to see was there mistakes made. And that is the bulk of what an appeal is. An appeal is asking the higher court, in this case, the military high court, please review the military trials that just took place where Mr. SR was found guilty on these 9 indictments. Please review all the investigation prior and everything else that happened in between, including everything that happened during trial that led up to the verdicts. and see if there was a mistake. My party, the defense, says we believe there were mistakes. Here is a list of the mistakes. Out of all of these mistakes, we would in particular like to highlight A, B, and C. And once they've given a submission for a request for an appeal, everything that else that takes place, everything that I've talked about in all the legal lives, all of them are not prep work. All of them are part of the appeal. Every stage, every step that we've discussed, and you can find all those steps on VLM YouTube. We're at stage 9 right now, right? The review. All of them are actual steps of the appeal. The result of the review is what the person is asking about. An oral hearing. Will there be an oral hearing, since I said it's not a trial? Depends on what jurisdiction you're in. Many jurisdictions in US have oral appeals and others do not. In South Korea, an oral appeal is almost always had when the appeal has been accepted. An appeal being accepted means that I am accepting the fact that there might be a cause for error and we will review it. An accepting of an appeal does not mean I accept there's been errors, period. That's a different thing. So an acceptance of an appeal means that court has decided to hear out the person or the party that has brought the appeal. So far, in stage 9, the review is proceeding, and there has been no denial of the appeal, meaning no one has rejected it yet. This indicates that the court has accepted the appeal. Now, this may change at the end of the review. Up until now, they seem to have accepted that there is reason to review for error. That's what they have accepted, that there is cause, there is reason to review to see if there is any mistake. At the end of their review, once that is completed, they may change their mind. If they change their mind, then the appeal will be completely rejected and it will be the end at this point. However, if it keeps proceeding, and at this point, there's every indication that this will keep proceeding because we're already at stage 9 and there has been no denial. If it proceeds, then where it will go next is a potential oral hearing. And that I say potential because there is a very, very small chance you won't need it. Oral hearing, but that small chance is extremely small, and in South Korea almost always, I would say more than 98% of the time you have an oral hearing. The oral hearing is a tiny percentage of the appeal process. The oral hearing happens after the entire review is done, and the oral hearing is kind of like that 5-minute presentation you do in your classroom after you've turned in your 10 to 20 page paper. So if anyone here is at least undergrad student or a grad student who's done 20 plus page papers and you have the bulk of your grade is on that paper, that 20 to 30 page or more that you've written, that has extensive work and you've probably spent an entire semester doing, that's your paper. That you get 5 minutes in your classroom to present that paper. The oral hearing is just like that. The oral hearing allows you to briefly highlight the key elements of your document, of the document you filed, which is called your legal brief. What was in the SR's legal brief? That gets presented in an oral hearing. Just like in class, you've done the real work for one whole semester and you've turned in your paper, 20 plus pages. In this case, we're looking at a whole lot more than 20 pages. In a legal case, we're looking at so much more. But the principle is similar. The real work is the paperwork. The review is done outside the classroom. The professor isn't going to sit there and read those 20 pages plus pages in the classroom and give feedback right then. The professor is going to take it back home and read it over a weekend or over their Thanksgiving break. And then they will make notes on the side and they will grade according to the rubric and criteria. Similarly, the review that's taking place right now is that they're literally reading the document, the 20 plus pages of paper, they're reading it, they're taking notes, they're looking at the rubric, and they're deciding, does this meet my standards for review? And what are my standards for review? To go back one more step in the question, what are we hoping for with this hearing? We're hoping that the oral hearing presents SR side that chance to clearly, concisely, and precisely. And these three words are so important. It might just sound like an everyday English word, but clearly, concisely, and precisely highlight and amplify the key claims being brought by the defense. If we have 20 plus pages that are being reviewed, we want to make sure we take our short few minutes that we have to present our side, and we want to be highly effective. The most effective appeal lawyers know during presentation what to leave out. They will more than likely give a very short summary of 1 to 9, but after maybe a minute or 2 minutes worth of summary, they will move on to actual substantive reasoning that they're going to use, and they're going to have to decide, do I want to focus on prostitution for self, prostitution mediation, embezzlement? Where do I focus my energy on? And that's all about the strategy. It's all about the strategy. So what we want with the oral hearing is an extremely effective pre-planned strategy that takes advantage of the short opportunity to present in front of the panel of judges. Their presentation should be so effective that when they leave that courtroom, based on that oral presentation, everything else that they reviewed gets put into perspective. So what do I mean by puts into perspective? By puts into perspective, I mean it helps them see point A and decide, point A should be taken under this context and should be viewed in this light to see that there was an error of law, or there was a reasoning error, there was a discretion problem. What were those problems? Where did they exist? Why did they exist? Here's my evidence. It needs to completely put all of those documents that were submitted as the grounds into perspective. So that's what we're really hoping for happens with the oral hearing. I think that this question that was submitted also has another factor that tells me there is some confusion in the community. What we're talking about right now is the appeal stage. The hearing that we're talking about, the oral hearing, is also part of the appeal stage. Once the appeal stage ends, the review is concluded and the oral hearing is concluded, we move on to the results. And one of the results of an appeal can be a new trial. And that is where there is major confusion in the community. They're confusing the result that can happen, new trial, with the appeal being the trial. The appeal is not the trial. The appeal is the review. The appeal is the review to find potential mistakes. And most importantly, to see that these mistakes were substantial in determining the verdict. And thus, this has affected the verdict, which we don't agree with. mistakes have been made that have resulted in a guilty verdict. If these mistakes did not exist, the verdict might have been innocent. That's what the appeal is all about. So the result of the appeal might be a new trial. And we need to be very careful to distinguish the two. The oral hearing during the appeal is not a new trial. The appeal is not a new trial. The result of the appeal might be a new trial. The result of the appeal might also not be a new trial. Sometimes, and if you go back to some of the YouTube videos, we've had one that says that there is something called remanding a case. Remanding a case means the appellate court has looked over everything. Oops, sorry, 1 second. Thread got extremely dry. It's water break time. Sorry, it's been a long day. It's 7:30 p.m. over here, and as you know, my career requires me to talk constantly. So let's go back. So the appeal court has reviewed everything. The oral hearing has happened, and for the sake of argument, let us say that the appeals court has decided there was at least one mistake that has led to a guilty verdict. Without that mistake, that guilty verdict would not happen. Without this mistake, this guilty verdict would not exist. Let's, for argument's sake, there is at least for one indictment they have agreed to this. Or maybe they've agreed to it for 2 or 3 of it. If they believe that this was substantial enough and the verdicts that turned guilty included prison sentence, so perhaps we're talking about substantial indictments that ended with guilty verdicts, such as embezzlement and prostitution mediation. These two are 4 if you see them separately. 2 categories, 4 indictments were substantial that led to his sentencing. So if these are the ones that they believe had something wrong in these particular parts of the reasoning, from investigation to evidence allowed in the court, to actually what happened in the court if there was a mistake in these processes. And we've discussed about the different types of mistakes before, so I won't go over it right now. And they believe those mistakes were substantial enough to have caused the guilty verdict. Without this mistake, this guilty verdict would not exist. Without this guilty verdict, this prison sentence would not exist. Without this prison sentence, perhaps he would only have some type of a fine. If those are the ones that they find problematic, then they might remand the case. Remanding a case is when the judges say, we think that it was a mistake, the mistake was substantial, it affected the verdict could have gone the opposite direction. If that is the case, I want the trial court to go back and hold another trial. And this time, I want you to interpret the law this way. This time, I want you to allow this evidence in. This time, I want you, when you have 2 different things, A and B, instead of giving more weight to A, I want you to give more weight to B. When you remand the case to trial court, you send them back with feedback. It's like when your professor grades your work and you receive it. I will be grading my students' work during Thanksgiving break and giving them a lot of feedback. When they receive it back the first day after Thanksgiving, it's going to have little red marks all over the thing. And it's going to tell them how should they have actually weighed certain evidence. Where should they have placed more emphasis? How should they have interpreted a law? How should that law have been applied? All of these things that I would do for my students for their paper that they're turning in this week are going to be similar, but obviously at a more professional judicial level done by the judge. So The trial court now gets back this document that tells them exactly the things that the appellate court think they did wrong. Here's your mistakes in big red marks. I want you to do A, B, C, D, and E to fix it. Time for you to go revise. And that revision work is the new trial. Just as my students will be revising their paper, if a trial court has been remanded SR's case, they will be rehearing his trial, but this time they have fully marked up paper with guidelines and guidance on where to place their emphasis and why. So when you go back into the community, there's two very important things to remember. An appeal is not a new trial. It is reviewing for mistakes and making certain did this mistakes cause the guilty verdict. Without that mistake, would the guilty verdict have not existed? Was it substantial enough to cause the verdict? If so, we need to find a way to fix it. If the mistake was there, however, that mistake was not consequential, it had no way of affecting the outcome of the guilty verdict, then it's not going to go anywhere. That's the first thing. The second thing is the oral hearing, which is a small part of the appeal, is your classroom presentation that you're doing that gives the highlights of your big research paper you're turning in the 20 plus pages, but you get 5 to 10 minutes in front of the classroom. Similarly, you turn in a 20 plus thing to the court, which is your real brief that has all the important legal reasoning and grounds, and they're reviewing that right now. But at the end of that, your party and the other party gets a chance to stand in front of the panel of judges and give them the highlights. Usually these oral hearings are very, very brief because again, they are the highlights. It doesn't take more than one day. So you need to be clear, you need to be concise, and you need to be precise, and you need to have a heck of a strategy. The best strategies will know exactly where to put the emphasis. So it's absolutely clear how all of that paperwork should be viewed in context and put into perspective. Finally, let's not confuse the new trial that people keep thinking with the oral hearing. If there is a potential new trial, that will only happen as a result of the appeal. If the appeal results in our favor, in SR's favor, then there might be a remand. If there is not a remand, but there is something in favor of SR, it can result in a reversal. A reversal during an appeal as a result is when they literally decide to reverse the verdict. Let's say they look at embezzlement and it was found guilty on 2 counts. They're going to go back and say, not guilty, not guilty. That's a reversal. When you take the verdict made during a trial court and you throw it out the door. That is another potential result that would be in SR's favor during this appeal. The third result that would be considered favorable for SR, and I really do mean the third because many people in the community have also expressed a concern of what they would consider a win. We don't look at appellate court wins and losses the same way as we do trial courts. In trial courts, if the defendants are found not guilty, it's a win. If they're found guilty, it's a loss. An appellate court, we look at each individual indictment. We also look at what they're attempting to do with the appeal. So with SR's case, they're probably going to choose a couple of strategies, either appeal all 9 or appeal the most relevant of the 9 that can substantially reduce any sentencing. For instance, the ones with embezzlement, the ones with prostitution mediation. If these 4 indictments in 2 categories were literally removed and were found not guilty, or had contributed some mistakes that led to the guilty verdict, if these disappeared, then SR might actually not have any prison term. Strategy: if you pick the ones necessary to fight and not mess with others, it could still lead to the result they need. If that's the case, then even one or two instances of favorable opinions from the appeals is still a victory for SR. So even if they get one or two favorable opinions, favorable conclusions from the appeals court, that has substantial benefit towards SR, it's still a win. Finally, in the same line, sentencing. As I mentioned before, the strategy that the people who bring the appeal have to be extremely solid, regardless of if you choose to appeal all 9 or parts of the 9. One of the things that I personally would do, and I would hope that his appeal lawyers are doing, is appealing the sentencing, regardless of what happens with the actual verdicts. No matter what, the sentencing should be appealed. So in this case, if the sentencing is appealed and they're able to successfully reduce his sentencing to anything less than 3 years, and if they're able to, if possible, get a suspension, then both of those, either reduction or suspension, are also considered a successful appeal. So I want to make sure we understand success in an appeal is not viewed in the same black and white way that you do a trial. Yes, you do have numbers that show number of successful appeals, and those are the ones that show you just the black and white. But in practice, we look at more than just the overall black and white, because most cases don't just have one indictment. We have 9 out of 9. A partial victory that actually accomplishes your goal is a victory. So keep that in mind. I do see another question directly related to what we're doing, so I'm going to answer that. And after I answer this question by Ayn, VIP, I will go back to another one that was sent to me. Do remanding really exist in South Korean system? If so, how frequently does it take place? Remanding definitely exists in South Korean system. If it does take place, again, I think you might have heard me previously when I've mentioned that there are no stats available for these. Keep in mind, South Korea as a democracy with its new form of criminal justice system was born in the 90s. Given the fact that it's newly born in the 90s, there are very few academic research that have all the data that you're looking for. In comparison, United States has been a country with a democracy for several hundred years. So has Great Britain. So keep in mind, we're talking about South Korea. There's a very big lack of academic research. There is also a very big lack of legal professions that do these kind of research on their own as an institute. We don't have, for instance, an Innocence Project in South Korea. We don't particularly have other organizations led by attorneys who are interested to look at mass incarceration rates, rates of wrongful convictions, of other factors such as, what would I say? Basically related to wrongful convictions. There aren't really a lot of research that are being done there. There's similarly not that many professors in universities over there who do these types of extracurricular research outside the field. So if you're looking for a stats, that stats unfortunately does not exist. Will it exist sometime in the future? Hopefully. In the last 10 years, research is slowly improving. Obviously, it's still new and there's still a lot to be done. So in the near future, there might be a lot more research done. I know that data on some of the police investigation is a little bit better today than it was, say, 7 years ago. When I was still studying at that point, there wasn't much around. I think it was maybe 2016, 15, where we had some more data come in. So keeping that in mind. How often are cases remanded? Cases are not very often remanded. After having said we don't have an exact data, I need to make sure we understand it is not often remanded. Just like the full victory that everyone is looking for doesn't happen often. If you watch my previous legal lives, you will hear me talk about the fact that a successful appeal, the real question isn't how successful is an appeal, what are my percentages, but how successfully are appeals planned? That's the real question that real lawyers ask, because all this data that you're looking at is looking at something so freaking general, and that has no way to apply it to each individual cases. Because again, when I talked about how often are appeals successfully planned being the real question, it's because the data we have collected, even the little bit of data that says it's not frequent, is from the fact that most cases, a majority of cases throughout South Korea, United States, England, wherever you have, are cases of average citizens. Average citizens do not have the resources. They do not have access to the best top lawyers. So when you are taking an average of average citizens, the chances of their legal team being able to successfully plan an appeal is not that high. So you have to understand where your data is coming from and where the number is coming from, and why even in outside of South Korea, the numbers usually look weak. It's because we're taking a sample population of general people, you and me. Our chances of winning an appeal are actually extremely low compared to someone who has the resources and the money necessary to get the best of the best lawyers in their country. Their chances are already above mine, already above yours. So keep all of that in mind. The real question is never what is the rate of an appeal. That matters a little, but how often or what are the chances a successful appeal is planned? Keep these in mind. These are the questions that my students work on instead of this arbitrary number that applies not to everyone. In SR's case, whatever general number someone might pull out a hat won't apply to him, because he is not your average Joe. He is not your average Korean who lives paycheck to paycheck and lives on the rooftop, who probably cannot afford their health care. So let's keep all of this in mind and in perspective. You're very welcome, mine. I will get to the probation question in a moment, as I have another question that's still related to the appeals. So let me go to the appeals, finish that out before I move to something like probation. Oh, motion sensor classroom. I need to walk for a quick moment. Okay, apparently getting up from the chair helps. This is Happy Nana. Basically, this is a result of a prosecutor who said he had no proof, and a judge unfortunately believed that he knew what was going on. Unbelievable. You guys already know VLM and my personal feelings towards what I called this particular case. Not only is it unusual, I have called this a circus all throughout. So that hopefully gives you an idea of my professional legal view of how this case went. It was a circus. So we will keep it at that, because it's not going to be productive if I go off on a tangent for right now. But absolutely, circus show, what I've said from day one. Okay, so I'm going to find my next question that was related to the appeal. And I'm trying to find the ones that are most relevant and the ones that will benefit everyone. So give me a moment. Okay, so here's an appeal question. The appeal question is, in this particular case, they're asking, is an appeal always automatically heard? And the answer to that is no. An appeal isn't always automatically heard. When I talked about accepting an appeal or rejecting an appeal, that's what I was talking about. Once you submit an appeal and you have all that grounds for appeal that you've turned in, the appellate court will review it first. But before they decide to actually study it, to examine it for mistakes, they first decide, is it worth our time to go through this entire stash of years and years of work to search for a mistake? So before they decide to review that entire stash, 3 years of it, they first take a shorter amount of time to decide, do I think there is a reason I should do this or not? That's the acceptance versus denial. So far, they haven't denied it. We're at stage 9 where they started the review of this entire document. The entire thing, they're actually now began reviewing it in October. So that means they have not rejected it. One of the things that I think is really related to this question is the fact we haven't heard anything yet. We were expecting to. If they decide to continue reviewing it, this is not a matter of news. What I mean is, in a normal legal case, let's forget SR, when you have a review and you decide to actually move on to the reviewing of the content, this is not a matter that requires the court to send out a type notification to media or anybody else that says, hey, we're going to keep reviewing. You just keep reviewing it. So hopefully that makes a little bit sense. The reason why we are not getting news is because this is all process that doesn't require notification. You don't have to notify someone if you're going to continue reviewing it. In October, started phase 9, stage 9, or step 9, whatever you want to call it, the review of the book. And because they have not rejected it until now, we can clearly see they're at this review stage. And that stage is not one that legally requires a notification to anybody. We already know they're there. By we mean the parties involved. In cases where media is involved, again, this is not something that requires media attention to say, hey, we're continuing. What you might hear, and when you might hear something, is at the end of the review, when the results are available. That is probably when you will hear something. If you'll remember our last live, I believe it was actually a sub-legal, meaning it was done for my students and not for VLM. So it was on my personal IG channel. We mentioned the fact that there is no time frame for this review stage because 3 years worth of work is being reviewed. And this is why appeals around the globe, no matter what country you are in, what legal jurisdiction you are in, can take months or it can take years. However, I do have a bit of an average to give you. Sometimes there's no data available, and sometimes you have some averages to look at. In South Korea, the average time frame of this stage is about 3 to 6 months. So an average time frame for an appeal is about 3 to 6 months, and the number will increase or decrease depending on how complicated the case is and how many indictments we're looking at. SR's case has 9 indictments and is quite complicated. So given that, it might increase. Also, it depends on the strategy used by SR's lawyers? Are they going to fight for the ones they believe are going to be most successfully overturned, and in turn, those will be able to reduce the sentencing or get rid of the sentencing entirely by suspending it? If they are focused on 4 instead of 9, then it might reduce the time frame. So the things that depend on the time frame is the length of the case that had took place, the number of indictments, the complexity of it, and the strategy used by the person and their team appealing. Their strategy, in this case, SR and his legal team's strategy, will be one of the main deciding factors of how long this review takes. So, as individuals who are interested in his case, whether you're interested because you're a lawyer yourself like me, or you're interested because you're a law student studying his case like my students in class, or you're interested because you're a VIP, you're IVIP, or you're a VVIP, what we all need to realize is there might be long periods of time where we don't hear anything, and that is just a part of the process. And it does not mean anything. All right, so hopefully that explains the question that was sent to me about this particular appeal. Let me see if there are any other appeal-related questions. Meanwhile, someone mentioned they had a question about probation. The person who has a probation question, if you want to go ahead and type that up for me meanwhile, I will get to that in a moment. Okay, so this one actually is not related to the appeal, so I'm going to wait to do this. It has instead to do with his military discharge. I mentioned that previously a couple of times, but I'm going to touch on it very briefly. But it's not related to the appeal, so I'm going to wait on that one. Someone had asked where he's at. He is at a military detention center. During this appeal process, SR is legally held in custody because he has been found guilty on 9 different charges. So SR is no longer innocent until proven guilty. The presumption of innocence ended when he was declared guilty during trial, meaning his sentencing is in effect and he is held in custody at the military detention center or the military correctional facility, however you want to call it. He will remain there until something changes in his case. The appeal will determine what happens next. So until then, he will remain at the facility. Hopefully that answers that particular question. So during this review process, yes, he will remain in detention. He will remain in custody. And it has nothing to do with him being SR. It has nothing to do with him being Mr. Lee Seung-hoon. This would be true if his name was James Donald or, I don't know, Pamela Pease. No, it would not matter what the person's name was. If they were found guilty at trial, then they would be held in custody during their appeals, regardless of who they are, what their name is, what their professional career had been, because they're no longer innocent. They're now guilty and they're awaiting an appeal. So hopefully that answers that particular question. All right, so as I said, I saw another question that was kind of not quite related, so we're going to wait to answer that. I'm going to come back on this side, attempt to juggle all the questions. No need to apologize for being late. Everyone has their own timing, and I'm just glad you were able to join us. Um, feel free to jump in and ask questions. What happens if the appeal took longer than his original prison term? Um, that's a really good question. In my experience, and I have fairly decent experience, but again, I want to make sure we understand that even though my legal experience is pretty decent and fairly extensive, I'm still rather young in the legal field. So I'm considered a young professional. So given my experience, I have never actually come across an appeal that has taken longer than an original prison sentence. That is because, uh, how do I put it? The appeal is the entire purpose of the appeal is to decide if there was a mistake and if the mistake caused the verdict, which caused the sentencing. So usually, if an appeal looks like it's going to outlast a sentence, then there is usually no appeal to begin with. You might remember from my last Legal Live and the one I did for my students, I actually mentioned that appeals are won or lost at the very beginning with the strategy. A lot of reasons why our numbers of appeals that aren't successful look that way is because lawyers, bad lawyers, take cases that should never be taken for an appeal. If your case will not be able to be completed before your person's sentencing has ended and you're their lawyer, you have no business taking this case to an appeal. You should be shutting down that appeal immediately because that appeal should never even be filed. So if you ever come across a lawyer who's done something like this, they're probably a very bad lawyer. Either bad meaning they're incompetent or bad meaning they have no professional ethics, because both of those will lead to a waste of their clients' time, energy, hope, money. And so a good lawyer does not take every case to an appeal. A good lawyer knows which cases actually qualify for an appeal and benefit for an appeal. So SR's case, based on what I have seen, should definitely not take 3 years or more, where again, looking hopefully at much less than that. But to answer, to do the final bit of answering, despite all of those things. So let's say SR's sentencing is 3 years, his appeal takes, I don't know, 3 years and 1 month. If that is so, then SR has basically served his sentence. Every day he spends in prison in military detention center is a day minus from his sentence. So if that thing takes 3 years, that's 3 years minus 3 years equals to 0 years. He'll be done serving his sentence, which is again why no lawyer in their right mind should be taking a case like that to court. If they do, bad lawyer, incompetent, or just, I don't know what kind of lawyer would do that, but maybe a very new lawyer. That could be possible. A lot of extremely new, bright-eyed, shiny lawyers who don't want to say no might try. But again, keep in mind, appeal lawyers are hopefully not directly out of law school. Knock on wood. I really would hope there aren't many who are like that, because appeal lawyers are very specialized lawyers. Not everyone who's not even normal trial lawyers can all handle appeals. That's how specialized an appeal is. Not even trial lawyers, all of them can handle an appeal. So let's keep this in mind. Yes, we've covered this a couple of times about new evidence, but to answer you, yes, in South Korea, new evidence is accepted at the appeal. South Korea allows the argument for both new evidence and your innocence. In America, you no longer can argue for your innocence and you can no longer present new evidence. In South Korea, you can do both. One of the plus points to their legal system. If someone during their probation, you're talking about their suspended sentence, commits a crime and are charged, in parentheses, put on trial, do they get the initial suspended jail sentence they received before, or the new trial can give a different sentence? This is a very good question. It's not 100% related to SR, but I will answer it because it might be. So very quickly, suspended sentence, when that happens, and if you commit a new crime, depending on what that new crime is, if that new crime has something that leads to a trial, because not always a charge, not all charges lead to trial. Some charges show up and then get dropped. But if your charge leads to trial and the trial leads to a sentence, then what happens? Usually you have to serve your suspended jail term that was originally given. So jail or prison. Jail is shorter, prison is longer, usually is how we define it. Jail is also for minor crimes. A prison is for more major crimes. So anyway, you would have to serve the original plus whatever you have been found guilty on freshly. If you don't get found guilty at the new trial for the new crime, so let's say that someone who has been previously charged with robbery and breaking and entering has a 2-year sentence that's been suspended, and during their probation, they committed a new crime. This time, they committed auto theft. So now they have a new crime. They get indicted, and the indictment leads to trial. The trial leads to a not guilty. If they're not guilty of auto theft, then they only have to serve the sentences from the original, the 2 years. However, scenario 2, they have the 2 original sentencing for robbery or burglary, whichever one I just said, and breaking and entering. They had 2 years for that. Then during their suspended sentence, they committed auto theft, or they're accused of it. That leads to an indictment. An indictment leads to a trial. This time, the trial results in a guilty. If they result in a guilty verdict for the new trial for auto theft, then they get the 2 years plus whatever the sentencing is for the auto theft. Hopefully that answers that. Next one. So that means if the appeal lasts 6 years, then he's detained for 6 years. No, that means that as soon as 3 years is passed, he has served his sentence. You're out the door the moment your clock strikes 0. So you have to make it smaller. Let's say you have 30 days, and every day you spend in prison is -1. So 30 minus 1, 30 minus 2, 30 minus 3, 30 minus 4, 30 minus all the way until you have a big fat 0. The day you have a 0 is the day you walk out of your prison cell. Similarly, the day SR hits 0, which is at 3 years, he walks out of his prison cell because he has literally served his sentence. There is nothing left to appeal, which is again why no lawyer in their right mind who is competent at any level would take a case that is incapable of ending and having a beneficial effect for their client. If SR's appeal has no potential of allowing him to have freedom, then that case did not even qualify for an appeal. So taking an appeal that takes exactly the same time as your sentencing to court means you're taking an unqualified case to an appeal, and that should never happen. In SR's case is qualified for an appeal. Even someone who doesn't have 3 years of documentation in front of them can easily see that it qualifies for an appeal. By that, I don't just mean it has grounds. I mean that there are legal benefits that exist for SR, mainly his freedom. He has the benefit of being able to come out of that prison cell before 3 years expires, and that is the entire reason one fights for an appeal. One doesn't fight for an appeal simply because you don't like the verdict. That's not why we do an appeal. We don't do an appeal because we didn't like our verdict or we disagreed with the verdict. We do our appeal because we want to see substantial benefit to the individual. In SR's case, this benefit that you and I are looking for, our goal is to make certain that instead of him being locked up for 3 years, he can walk out the sooner, the better. That's the goal. So anything that results in him walking out before 3 years is a victory. I want to make sure everyone leaves with this mindset. Any single thing that allows him to walk out, whether it is change in one verdict or 2 verdict or all of the verdict or the sentencing, all of those are successful goals that have been met. That does what an appeals goal is, to give substantial benefit to the individual so it can substantially reduce the time they're locked up and give them back their freedom. In SR's case, we're hoping sooner the better. How long can it take? Again, as I said, 3 to 6 months is the average. You add on more or you subtract some, depending on the complexity, depending on the strategy used by the person and their lawyer who brought the appeal. In this case, we are talking about SR's lawyer. Depending on their strategy. If their strategy is to focus on 4 indictments, it's probably going to be shorter. If their strategy is to force on 9 indictments, we're going to probably add on a couple of months if necessary. Strategy by the appellant lawyer is going to either subtract time from my 3 to 6 months or add time to my 3 to 6 months. I honestly know nothing about Han So-hee's case other than what I knew a couple of years ago. I have not kept up with it because it's not a part of my class curriculum, and my real life involves taking care of my parents, surviving COVID, which I just survived last month in case anyone wanted to know. I'm also involved in local politics. So Han So-hee and we have no idea of what's going on in her life. If someone actually wants to learn about Han So-hee and wants to share information about her case, you're free to DM me. But again, Han So-hee, I have nothing that I know about their case beyond what I knew about 3 years ago. So I cannot give you any legal substantial information beyond what happened 3 years ago. However, his address is going to be exposed unless his guilty verdict is overturned. Excellent statement. This brings me to the cross section of the next question I'm going to answer. And this question is going to be a doozy. But I'm going to have you guys wait on that because I think I might have skipped one question at the very top from Pam. So give me a moment. If he have not been detaining in court, could he have gone home after ending his military service and wait for the appeal to start, even without being in jail? Let me answer that one first, and then I will go to the one that I just read a moment ago. Okay. If he had not been detaining in court. Could he have gone home after ending his military service and wait for the appeal to start? The only way SR could have ever left to go home is if he was found not guilty. So the only way an individual who has been charged with a crime or with multiple crimes can go home after a trial is when the trial results in all not guilty verdicts and he does not have any sentence. If he has been found guilty and that guilty verdict comes with a sentence, they are immediately in effect. So if SR's case took place in civilian court as opposed to military, and he was found guilty of, let's just say let's say he was found guilty of embezzlement and he was sentenced to 1.5 years in prison, he would immediately be taken out of that courtroom and taken into custody so that he could serve his 1.5 years. He would have his 7-day period in which to decide to appeal or not to appeal. If he appealed, the entire process of his appeal would be taking place while he would have been held in custody, in civilian custody. So the only way any individual, regardless of what their name is, can walk away from a trial to go home is if they're found not guilty. That is the only way any individual in any country, including Mexico, United States, Canada, UK, Germany, France, Italy, India, Pakistan, Bangladesh, Japan, South Korea. I'm not sure about the dictatorships. So minus the dictatorships, there is no country in the world where a person who has been found guilty and has a prison sentence can go home. You've been found guilty. You are immediately serving your prison sentence because, again, you've been found guilty. So under no circumstances would SR have been able to go home with a guilty verdict that had a prison sentence. The only way SR could have gone home is if he was found not guilty, or if he was found guilty on something that had no prison sentence. He was found guilty of jaywalking. Jaywalking doesn't have a prison sentence. He was found guilty of, I don't know, parking your car in the wrong place. That has no prison sentence. He was found guilty of perhaps something that has absolutely no prison sentence attached to it. Then you can go home to clear your name. But again, if you're found guilty and your crime is a crime that has a prison sentence, you are immediately taken into custody to serve your prison sentence. What happens during that period of time is up to you. You either accept your verdict or you challenge it through an appeal. So SR decided to challenge his through an appeal. I'm hoping that very clearly explains why a person would be in detention instead of at home, because they're guilty by trial court verdict. And the only way they're not guilty is if an appeals court reviews this case and either remands it or reverses it, or does a partial remand or partial reversal. Sorry, a partial reversal. It cannot be a partial remand. If it's remanded, it's remanded. Okay. How is his address? Okay, let's go back to the exposing of his address. There has been some major confusion on Instagram, but mostly I've seen the reports coming in from Twitter that they believe that SR is going to be on a sexual offender registry. Give me a moment so that I can actually pull something up for you. Or actually, I don't think I can pull it up on this computer. I will instead pull it up on my cell phone. Hopefully. Okay, so the idea that has been circulating is that he's going to be on a sex offender registry because he was asked to release his personal information. And because sometimes people overthink things, I would like to say that sometimes things are as simple as they seem they are. In this case, it really is just as simple as it sounds, and it is give the court your personal information. At the end of every trial, regardless of whether it's military or civilian, a person's personal information is collected. These personal information is released to the court so the court can record all of it, the date of birth, your job, and they put all of that into your record. The record we are talking about in this case is going to be your criminal record. So a person who has been found guilty of crimes has a criminal record. That is true for no matter what country you're at. If you've been found guilty, you have a criminal record. The personal information in this case is collected by the courts in order to establish your personal file that has your name, date of birth, your citizenship information, your residence, basically your life's resume and anything else included that goes into this criminal record. Thumbprints, sometimes if your crimes had anything to do that required your DNA might be in there. So depending on what kind of crimes you were convicted for, different types of information might go into your criminal record. So personal information in this case is personal information to put into an individual's criminal record. Sexual offender registry is something completely different. South Korea has something similar to a sex offender registry, but I say it's similar because it isn't. Not every sex-related offense is considered a sexual offender type crime. In particular, South Korea focuses their registration. Oh, hold on 1 second. My computer wants to restart. Remind me tomorrow. Hopefully it won't restart on me randomly. I just click remind me tomorrow. Okay. Sexual offenders in South Korea are very limited. We call this scope. The scope of registration is only for offenders of children. And I'm going to repeat this one more time. No matter what you see out in that wide world of news and gossip and assumptions, and I say this because there's so much of assumptions, in practice, the scope of the registration for sexual offenders is limited to child sex offenders. Meaning, if someone has sexually molested someone who's considered a child, if someone has sexually, harassed someone who's a child, if someone has kidnapped and raped a child, if someone has done a sexual crime towards a child, then they are put in the sexual registration for the offenders. So it's very, very, very targeted in its scope to children-related offense. And none of SR's indictments, none of the indictments for which he has been found guilty have anything related to children. Prostitution for self had no relation to children. Prostitution mediation had no relationship to children. So he has absolutely no child-related sexual offense for which he was indicted or found guilty, meaning the scope of the sexual registration in South Korea does not include SR, and he will not ever be forced to or even qualify to get his name on it. I've been asked, what is the name of this? How do we know? And I mentioned previously, it's actually pretty easy. It's actually called um, Youth Sexual Protection Act of 2000. So Youth Sexual Protection Act of 2000. I'm going to actually put it right down here in my comments so you guys can actually look it up on your own. Because sometimes it's best when you use your time and energy to do some of the research yourself. This is it. It's the Youth Sexual Protection Act. And even the name of it has the word youth in it. There is no way to misinterpret this. Absolutely no way. The words spell out Y-O-U-T-H. We're talking children. One of the other things that I think I could do for you in order for you to feel slightly better about this, and not that there is any way to really feel better about this, is to understand that, I need to walk again or stand up again. Okay. That the website itself is really very focused on children. I'm going to also put in the South Korean name that is attached to the website so that you guys can look at it. Oop, I think there is, here you go, the South Korean word that is attached to it. So in other words, sexual offender registration for SR is not a possibility. And again, it's in the name of the website itself. It's also in the name of the act. The act is the legal document. The name of it itself says so. However, let me see if I can actually give you an American version of that information that you can understand. If I can find one that has some English information for those of you who really, really like to do your own research before trusting information that comes through online sources, including VLM, and that makes a lot of sense. So one, I would say go look up .act yourself. Number two, give me a moment while I attempt to actually find an English version. Not an English version, but an article that discusses it. I had one earlier, but it's been a couple of days since I was talking, so it kind of disappeared on me. Where is it? There was something very, very possible for you to see, and it's in English. Okay, here we go. Here we go. Here we go. All right, I'm going to give you the PDF. It's going to be in English. You're going to go down to the country South Korea, and we're going to look at it at the same time so that you guys can see what I'm saying. So click on the link, please. So click on the link. So to answer, is his address going to be exposed? No, his address will not be exposed. The criminal record that people have are not exposed to the public. The criminal records remain with the law enforcement agencies, and those are usually only released to employers. So to answer that, no. And sexual registration, no. Guilty with suspended sentence equals go home. Correct. If that is what happens, then you can go home. But unfortunately, we're not there. If there's one individual at home waiting for their appeal, did they not have a prison sentence, perhaps? I would have to look at their individual case, but it makes no sense if a person has been found guilty and they have a prison sentence that they're waiting at home. Because again, if you're found guilty of robbery, you obviously are now a convicted felon who is supposed to be serving his sentence, however long that sentence is. So a robbery felon convicted and found guilty doesn't sit down at home where he can potentially cause more harm to society. Instead, he immediately, the moment the case is over, gets handcuffed and taken to custody. So you get found guilty and you have a sentence attached to it, you don't go home. I will refer to the fact that I am not 100% up to date with other individuals' criminal cases. So I will not take a guess at things that I am not 100 up to date with. And I tend to do this all the time. I know it's frustrating, but again, anyone who has a legal background, who takes stabs at guesses without actually following a case, I would say there's lack of ethics there and they're no longer credible. So I would attempt to not answer that question about JJY because, again, I have not kept up to date with their case, real life calls and school calls and everything else. Why not all criminals are asked to do the registration? Not all criminal records are of the same nature. Okay, so I'm assuming everyone has opened this document and scrolled down to South Korea. I want to see a yes or a no. Yes or a no. Have you scrolled down to South Korea? If you have, I'm going to read it out so that you can follow. First thing is we're going to say when it was enacted. It was enacted in 2000. There is a public notification system available. Public registration website exists, and it's posted for about 5 to 10 years, depending on your sentence. Okay, all of that sounds standard. I'm going to go down to scope of registrable offenses. The scope, I mentioned the word scope before. Scope tells you what are the limitations, what can be used for registration, what cannot be, who can be registered, who cannot be. And in plain English, any offense against a child, that is the scope. It cannot exceed this. Any sex offense against a child. And then there is a bit of a discussion below with your website that you can go to. Any person convicted of sex offense is subject to targeted public notification website. The length of the time that an offender's information is made available is dependent on the incarceration, the length of the offender. But one of the things that you need to notice is under scope. Literally says related to child. And again, you are not going to find too much of details online. Again, South Korean information is not always readily available. There aren't also a lot of South Korean lawyers who practice outside who talks about this. But on the side, you see references. Act on the protection of children and juveniles from sexual abuse. There is your reference. Also, there is a website for your reference. Child, children, youth. So hopefully you will take this piece of information that the scope is extremely limited and there is no children, youth, juvenile related to SR's case. And thus, he does not meet the scope. He does not meet the scope, period. There is nothing there left to argue because he doesn't meet the scope. Thanks for sharing the PDF. It's very useful. I'm glad it's very useful. Those who want to save the PDF, because I see some people might not be able to open it immediately. Save the PDF, scroll down to South Korea, and after you look at some of the basic information, go straight to scope. The scope tells you child, and on the side where it shows you the reference, it tells you where you get your actual references and the website. So it's child oriented. I want to make sure that everyone who goes back to their social media puts a stop to the rumors that are flying around like wildfire. So let's put out the wildfire, people. Grab our fire trucks and fire hoses and let's put out this wildfire, because misinformation is a dangerous thing. Misinformation confuses our public. Misinformation teaches other people wrong things. Misinformation does not help SR's case, because when we spread wrong information, later on, if we correct ourselves, we've lost our credibility. Misinformation also will make it less believable to the public when you do talk to them about credible information. So let's make sure we put full stop to any misinformation that circulates. Send them to watch this. Hopefully this will be saved properly without any technical difficulty. So send them to watch this. Send them to VLM. Send them to my personal IG. And I can talk to them personally. Again, I have personal experience practicing in South Korea. Unlike just reading something online and trying to understand it. Reading something online and trying to understand it requires you to try to connect points without really understanding what these points are. When you practice, you already know what those points are. So you don't have to spend time guessing, how do I connect to this? You already know how are they connected. All right, so hopefully that one was answered. Exactly. There is no registration for any other type other than child related. Okay, the next question is actually relatable but unrelated. And this is going to be a problem because society sees everything as chunked and lumped together. But the distinction exists. So we're going to discuss this part. SR has been indicted and found guilty on prostitution and prostitution mediation. There are different categories of crimes. The category of crime that is prostitution and prostitution mediation falls under sex crimes. So this is where the thing gets muddy. While he will not be on any sexual offender registration, it would not be incorrect if a person says that he is guilty of a sex crime. Would we call him a sexual offender? Usually prostitution and prostitution mediation are not included in what we call sexual offenders. Sexual offenders are usually people who make offenses of sexual natures that are more violent. For instance, I will just use the most easiest one, rape, gang rape, other things that are more violent in nature. However, even though we wouldn't consider him to be a sexual offender, he is definitely an individual who's been found guilty of sex crimes. So in the general public, and this is why I said it gets muddy, it gets tricky. The general public does not see the distinction between being found guilty of a category of crime that falls under sex crimes label versus being a sex offender. The general public does not see that distinction, and they would technically still be correct to use those terms, even though legally there is a very big distinction. And this is where, again, the society and their understanding and their jumbling of words together is going to be difficult for the rest of the community, because then when you discuss prostitution and prostitution mediation, you're going to have to be very specific and very careful in your word choices. So you acknowledge, yes, these two fall under the category of sex crimes. However, they do not qualify him to be considered as an offender. And legally, they're two different things. But in general society, you just clump them all together and make one. So we're going to have to be very careful in the way you discuss it. As far as this last part, until the verdict is reversed or changed, you're correct about that. If the verdict is reversed or it's been remanded to the trial court and they do a retrial and now he's found not guilty on prostitution and prostitution mediation, then he no longer is someone who's been found guilty of any sex crimes. So if that happens, then he's no longer found guilty of sex crimes. And you can, at that point, actually argue for his innocence. You can argue for the fact that he was innocent all this time. So again, excellent questions, really. So I've tried searching on that website, and it requires anyone who has escape phone number, residential, it needs more information. Like, yes, that website is not something that just anyone can use. It's public, yes, but if you're not South Korean, you don't fall under the privilege of being able to see other people's information, because that website literally has sexual offenders registered who have committed sexual offenses against children. So if you're not living in South Korea and a South Korean resident, you probably are not going to find it. So in other words, what that means is that not every Tom, John, Jane, and Henry can look up a sexual offender's information in South Korea. And in South Korea, a sexual offender who's registered is one who has committed an offense against a child, a sexual offense against a child. Let's always remember that. Okay. Molka definitely is also a part of the sexual crimes. Yes. All right, guys, it's now 8:43. We've been doing this for a little bit more, actually quite a bit more than an hour. I'm going to attempt to wrap this up in a few minutes so that I can go home by 9 p.m. So let me see if there's one more question that I can answer. And while I'm looking for one more question on my phone that was sent to me, if you guys have any last questions to wrap up, otherwise we're going to look to see any last minute questions, concerns that were sent that is related to this. And again, those who came in a little late, I mentioned that my classes are wrapping up for the semester. This means that my law students will have at least one more legal supplemental material presented to them on my Instagram channel. So keep an eye on it. It's going to be extremely legal. It's going to be extremely law related, because we've spent some time in class discussing all the 9 indictments and what our strategies would be and what would be the strongest grounds for appeal. So during that live, I'm going to present what would be the strongest grounds for appeal. So if you want to know about how our classroom has broken it down, then feel free to join me for the Saba Legal Live on my personal Instagram channel. It's a supplemental material for my students, but again, I hope it's going to be extremely useful for the community as well to see what we've come up with and why. Okay. The last question I'm going to then answer is actually, again, just related to the questions that were sent to me. I mentioned before that results of the appeal can result in a reversal or a remand. There is the last thing that it can result in, and that's what we called an affirmation or an appeal being affirmed. Affirmed really is when the appellant court has agreed with the lower court's decision that that decision was correct and made without error that was prejudicial. The word prejudicial is very important because if it was made without error that is prejudicial, that means that there was nothing that affected the verdict. So, and my question over here that I received was, can SR's appeal result in some acceptance and some denials? And what I think you're meaning is, can SR's appeal, because there is 9, can there be 1 or 2 that are affirmed and some that are not? If that is your question, and I think it is, then the answer is yes. Out of the 9, perhaps they might affirm gambling. Out of the 9, perhaps they may affirm illegal monetary exchange. However, they might not affirm embezzlement, or they might not affirm prostitution mediation. So there can be a mixture of affirmation of 1 or 2 indictments, meaning we agree with the results, the lower court's decision that SR is guilty of gambling. SR is guilty of illegal monetary exchange. And do keep in mind that SR did plead guilty to 1 indictment. So that particular indictment hopefully has not been appealed and it will remain as is. So other than that particular one, there might be 1 or 2 that get affirmed. And the others, as we said, could possibly be remanded, or it could be reversed, where you basically throw out the lower court's decision of guilty. You like throw it out the door. Like, we are reversing this guilty verdict. We don't believe it was accurate. There is also the possibility of modification. The modification is usually goes hand in hand with reversal or goes hand in hand with a remand. Modification plays a bigger role if you have that mixed result where 1 or 2 are affirmed. A modification might then modify a part of it. A modification may also be directly linked to modification of a sentencing. So instead of 3 years, maybe we get the things all recalculated and it goes down to, say, a 2-year sentencing. And then the 2-year sentencing is, let's say, further used with mitigating circumstances to turn it into a suspended sentencing. So 2 years, sentence suspended for 1 year and 3 months. If that is the case, then we are talking about a modification. Hopefully that answered it. Yes, you can have a mixture. If you have a modification, that's usually going to be another place where you see a lot of that mixture. It doesn't have to always be all or nothing, which is again why I remind everyone in SR's case, we're not looking for a black and white result from the appeal. We're looking for a result from the appeal that for him is considered a success. It could be a reversal, it could be a remand, it could be a modification, it could be related to the actual verdicts, or it could be related to the sentencing. Ultimately, the goal is to make certain we benefit SR, and in this case, the benefit is releasing him from prison and making sure he spends less than 3 years. As less as he spends, the better it is. So if we get any results that make it possible for him to not be spending 3 years in prison, then that is actually a success, regardless of what the data says. The goal, again, in that case, is how does this benefit SR? And that is the primary goal of the appeal. Okay, anything else that we finished talking about before? We're really not going to touch on that so that I can go home. Anything you missed? You can rewatch this, or you can watch one of the very many other lives that I have done, because I've mostly touched upon just about everything. So he doesn't need to register. No, you cannot register for sexual offender registration because he is not a child sex offender. He's probably doing wartime labor already. I will not touch upon that particular instance because I do not know what the MMA has decided about his military service. What their decision is over there will depend on several factors, and I don't know what MMA decided, so we're not going to touch upon that particular one. Okay, we've already talked about chances of appeals, percentages, reversals, all of those things. So again, we watch. Wartime labor, I think, is just a way that they use that word. In South Korea, it basically means non-active military service. If you, like Tabi, have been found guilty of particular crime and have been sentenced to a particular number of years in prison, with or without suspension, you may no longer be qualified to be an active service member. So as far as SR that we know, his service is suspended. He was not able to complete it. He was probably just a few days short of completion before he got found guilty. So his service has been frozen, and until the MMA decides what to do with his service, we do not know what will happen. And the MMA might not make that decision until the appeal ends, because if he is found, if the appeal reverses everything and he's not found guilty on some of those, or if his sentencing is changed, then he may be qualified to finish his service. So the result of the appeal, even if it is as simple as changing his sentencing, it can make him qualified to finish the remaining bit of his military service. So until MMA decides where it is at, and more than likely they will not until they have a final result from the appeal. We don't know, and we cannot jump to conclusions on that. Again, as legal professionals, we really do not jump to conclusions because we know that these decisions cannot be made until the appeal is finished. Similarly, I think the community also cannot jump to conclusions because unless you know the results of the appeal, you also don't know what the potential is for the MMA's decision. So there definitely has the possibility. Okay, thank you for this explanation.